This article has 3 clauses and each clause provides protection in different fields. Firstly, we will see the protection provided by clause 1 of article 20, which can also be said to be a protection against ex post facto penal law. This clause declares that no person shall be convicted for violation of a law not in force at the time of the offending act. Conviction can be made only in respect of that law which was in force at the time when the offending act was done. If that act was not an offense at the time when it was done, then it cannot be made an offense with retrospective effect. This is the first proposition of law which is made in this clause. As regards the penalty, this clause declares that no person shall be subjected to a penalty greater than that inflictable at the time of the offending act. If an act was an offense at the time when it was done, then of course it is liable to a penalty. But only that much penalty can be imposed which was in force at the time when the offending act was done. The penalty imposed cannot be greater than that which was inflictable at the time when the offending act was done. It does not say that it can't be lesser. So by inference, we can say that a lesser penalty can be imposed. This clause prohibits a greater penalty. So this is clause 1 of article 20. Then there is clause 2, which provides protection against double jeopardy. This clause declares that no person shall be prosecuted and punished for the same offense more than once. For one offense, there can be only one prosecution and punishment. Clause 1, Clause 2 and Clause 3 of Article 20 apply to all persons. This is in sharp contrast to the provisions of Article 19. The rights granted by Article 19, as we saw, are available only to citizens, but the protections provided by Article 20, all the 3 clauses are available to all persons. And this is the third protection provided by Clause 3 of Article 20. We can call it as protection against self-incrimination. This clause declares that no person who is accused of an offense shall be compelled to be a witness against himself. This clause admits a possibility where an accused person can himself volunteer to be a witness. And when he is a witness, he can speak against himself also. That is permissible. What is prohibited, what is banned by this clause is that he cannot be compelled to be a witness against himself. If a person is accused of an offense, then he cannot be compelled to be a witness against himself. He cannot be compelled to self-incriminate. Now, there is an important issue concerning involuntary administration of narcoanalysis, polygraph examination, and the brain electrical activation profile techniques. This issue was elaborately considered by the Supreme Court in 2010 in Selvi versus State of Karnataka, and the court issued certain guidelines in this judgment which are of great importance for all persons in India. The question here was, what is the scope of the right against self-incrimination which finds place in Article 20, Clause 3? This judgment determines the scope of the right against self-incrimination, the scope of clause 3 of Article 20. This is the decision. The court says that irrespective of the need to expedite investigations in such cases, no person who is a victim of an offense can be compelled to undergo any of the tests in question. No one can be compelled to undergo any of the tests in question. Such a forcible administration would be an unjustified intrusion into mental privacy and could lead to further stigma for the victim. The court says the compulsory administration of the impugned techniques violates the right against self-incrimination. First, it was talking about intrusion into mental privacy, which is unjustified. So the court calls it as unjustified intrusion into mental privacy, because privacy is also a fundamental right. And now the court is talking about violation of the right against self-incrimination. Compulsory administration of the impugned techniques violates this right, and this is because the underlying rationale of the said right is to ensure the reliability as well as voluntariness of statements that are admitted as evidence. Article 20, Clause 3 protect an individual's choice between speaking and remaining silent, irrespective of whether the subsequent testimony proves to be inculpatory or exculpatory. Article 20, Clause 3 aims to prevent the forcible conveyance of personal knowledge that is relevant to the facts in issue. That knowledge may be relevant to the facts in issue, but that is personal knowledge, and you can't force conveyance of this personal knowledge from the accused. Finally, the court issued certain guidelines. The first one is this: no lie detector test should be administered except on the consent of the accused. The accused has a protection against self-incrimination under clause 3 of Article 20. No lie detector test can be administered on him except on his consent. Second, if the accused volunteers for a lie detector test, then he should be given access to a lawyer, and the physical, emotional and legal implication of such a test should be explained to him by the police and by his lawyer. And the consent should be recorded before a judicial magistrate. And finally, the court says that the actual recording of the lie detector test shall be done by an independent agency such as a hospital and conducted in the presence of a lawyer.